appreciate it if the questions you had pertain to the trial and the proceedings. I know it's been a while and you haven't had an opportunity to ask those questions, so that's what we're here to do. So there's not going to be an opening statement. We'll just jump right into it. So.
I think everybody was curious about the timing of yesterday's decision. What role did the fact that there was a Castigar hearing scheduled play into that? As you know, a Castigar hearing is very rare. You had to prove that nothing in your case, in the state's case, was based on Officer Miller's previous testimony. What led to that decision yesterday?
I don't think the Castigar impacted the decision, except for the fact that the Miller case was scheduled to begin that day. You'll note that we nalprossed 3 cases yesterday. The Alicia White case did not involve any Castigar hearing. The Porter case, the Castigar hearing would have been a minor event. We had fully tried the Porter case and there was a complete record on it. So the fact that a Castigar hearing was coming up in the Miller case was really not part of the consideration. We didn't think we would have any problems getting past the Castigar hearing.
It seems
what
that
type
one
of
part
meetings
of the
occurred between the two of you and members of the clean team?
Well, let me explain. I don't think people quite fully understand what the concept is. There is no law in Maryland about whether a prosecutor exposed to an immunized statement can then prosecute the subsequent case. In the federal circuits, there is a split in authority, with some federal circuit courts saying if all the prosecutor does is read the immunized testimony, that's no problem. That prosecutor can then prosecute the person who is the giver of the immunized testimony. Other federal circuit courts say no, the mere knowledge that the prosecutor has is a sufficient basis to preclude the prosecutor from going forward. Maryland hasn't decided that issue. We decided, based on comments from the court when we first raised it and taking a very conservative position, that we would get prosecutors who were not exposed to the immunized testimony. And they were not exposed to the immunized. We went to great length. We had what is called in the vernacular a clean team, which means they're clean in the sense they were not exposed to the immunized testimony. We also created a filter team, which filtered, if you will, all evidence before it went to the clean team so that we could have another prophylactic step to make sure that the clean team was not tainted by knowledge of immunized testimony. So there was no requirement that we not be allowed to talk to people on the clean team. We have an office to run, and they work here, and so we need to talk to them, and we do talk to them. But no immunized testimony was ever disclosed to the clean team by the filter team, by any of us, or by anybody else. They went to great lengths, and they're to be commended for the efforts that they made to keep themselves free from taint from immunized testimony. They did a very good job of that, and that was not a concern at all.
Sir, is there any
this is the first time that you've been able to address in public this case, which really has gripped the nation. And I'm wondering, can you talk about how you pieced together your theory of the case, how much of the investigation took place before the indictments, and did you feel rushed? The defense has alleged that you rushed through it.
Well, the defense has alleged a lot of things, and
but can you talk about how you pieced together the theory?
Well, I think we pieced together the theory from the facts, and I think that one of the things to keep in mind is that the police investigation prior to the death of Mr. Gray was done by the FIT team. This big task force that they put together, they did not put together until after Mr. Gray's death. We started investigating the matter the day of or the day after Mr. Gray suffered his injuries. And while we were investigating, we were receiving information from the police department on a daily basis. We had the information that they had. So I think, you know, and Jan, maybe you
Right.
care to comment on, because you were directly
Yeah,
involved
and
in
I can
this.
tell you, we began meeting with BPD starting as early as April 13th. And we met with the FIT team on April 14th. We had been gathering information from BPD, including statements from witnesses and officers. We had sent out, we had made requests for CCTV footage. And so that entire week, I was spending all day working with BPD and reviewing evidence as soon as it came in. I mean, we were in constant contact with them. The task force didn't start until after Mr. Gray died. And at that point, a fair amount of evidence had already been collected and reviewed, both by BPD and by the Baltimore City State's Attorney's Office.
So was this a rush to indict?
I don't know how you say
I don't know.
I don't think that we felt we were rushing. I don't think we felt that there was material that was overlooked. I think that much of the evidence was in the statements of the officers who gave statements, and those statements were all in by April 17th. So, and if you sort of looked at a timeline from April 12th until the day the indictments were returned, I don't think you wouldn't see a curve going up of increasing evidence as we approached the day of the indictment. I think it would be to the contrary.
Would you shed some light on what the state's attorney meant by couldn't execute warrants for the officer's cell phones?
Okay. I think Ms. Bledsoe is in the best position to answer that, and we'll answer that question. But generally, we're not here to explain. Mrs. Mosby can fully explain what she meant by everything, but since that relates to an investigative task, we're happy to answer that question.
So we had obtained search and seizure warrants for the officers' personal cell phones. And those warrants went unexecuted
By police?
by the police. So you all know that there's X amount of time for a search and seizure warrant to be executed. And the Baltimore Police Department did not execute those warrants in the correct amount of time, and they expired. And so
Did they give you an explanation as to why?
there was an explanation given as to why.
What
Yeah.
was the
Which,
explanation?
which was not given by command. It was sort of more by lower command.
How much of a difference would it make in the case if you had those cell phones?
Kind of hard to.
What were you hoping to glean from those cell phones?
Hard to answer the question without having the cell phones, but obviously it would have shown what communications they were having and who they were having communications with and when.
During this trial, there was a talk about the seatbelt.
PK.
During this trial, there was one of the main points was Freddie Gray was not putting a seatbelt, and it seems that you guys were trying to convict him on the general order that required prisoners be seatbelted. First, why did you go that way, and did you realize how tough it was knowing that the Court of Appeals ruled nearly 2 decades ago you can't convict on a general order.
Well, in the first place, I don't think that's what the Court of Appeals said, that you can't convict on a general order. A general order is relevant to the question of whether there was a violation of the law. And we start with the basic proposition that under the Constitution of the United States and the Constitution of Maryland, that the police have a duty to ensure the safety of people in their custody. And a seatbelt is one way to ensure the safety of someone who is handcuffed with his hands behind his back, legs shackled together, and placed face down on the floor of a van. That being restrained by a seatbelt is not only what we think is a rather obvious safety device, but it's something that was required by the general orders, which are designed to guide the conduct of the officers. So why do we do that? Those were the facts that were available to us. That's the law that was available to us. That's what we thought was an important indication that the involved officers who were charged with that specific violation had not done what they were supposed to do.
At the same time, the judge said, particularly in the Goodson trial, that there was ample case law that says that general orders general orders doesn't mean that someone was criminally negligent.
In and of himself, but the judge also remember that in these cases, with the exception of one count, which did not make it past a judgment of acquittal for legal reasons, not evidentiary reasons, the judge, as a judge, found with regard to every single count that we presented in trial, including the ones that were focused on seatbelts, that there was sufficient evidence for a rational juror to find proof beyond a reasonable doubt and convict. Now, the same judge sitting as a jury didn't find that the evidence was sufficient for him to convict, and that was his right to do that. But it's not a situation where there was no evidence. There was sufficient evidence for a rational juror to convict based on the judge's findings, but the judge sitting as a jury simply didn't credit all that evidence, and that's his right to do, and that's how our system works.
There are text
Juliet,
messages.
please ask your question.
Thanks. Were any of the officers charged offered any sort of deal?
I don't really think that it's appropriate for us to talk about that, so I just don't think we can answer that
Okay, I have
question.
a second question then. Can you talk about if you explored the theory that Freddie Gray was injured before he was put in the van, and how you ruled that out?
Well, we ruled that out on the basis of the medical expertise available to us. You know, the medical examiner, I guess technically assistant medical examiner, Dr. Allen, specifically looked at that issue. We certainly had that corroborated by the outside expert neurosurgeon, Dr. Soriano, we consulted. As we argued in court, looking at the film, the two sort of most important aspects of that, at least to me as a layperson, were that when Mr. Gray was on the ground, right in front of the low retaining wall, if you watch at one point, his chin comes a full 4 or 5 inches off the ground. And then later, when he's taken to the police transport vehicle, there is a period of time where he is standing on, I call it the tailgate, I don't know what you call it, it's the black metal piece that comes out from the back of the wagon, and he's standing there bearing his own weight. And those two things seem to be inconsistent with the injuries that he suffered that caused his death having occurred before those two things happened.
Sir, do you feel like you would have gotten a different outcome if these were in front of a jury? And do you lament that right of a defendant to choose that, as Mr. Mosby seemed to suggest yesterday in a press conference?
Well, I don't know if lament is the right word. I do think it's fair to point out that in the state of Maryland, it is up to the defendant and the defendant alone. If you walk across the street and you're in the federal courthouse, the prosecutor and the judge both have to agree before a jury trial could be waived. We know, if we credit the reports in the newspaper, we know that some jurors were persuaded beyond a reasonable doubt that a crime had been committed. Others were not. So whether the result would have been different or not, your guess is as good as mine, but it's certainly a possibility.
Your decision to not move forward that we heard about yesterday, does it have anything to do with your clean team and Miss Lisa Phelps not wanting to prosecute that? There's some of that floating around out there today. Is there any truth to that?
There was no issue. The clean team was in no way tainted. The clean team could have tried that case. Others could have tried that case. That had nothing to do with the decision not to go forward in these three cases. The cases were treated. Look, we looked at each case individually, obviously, but the decision was a decision that went across the board, and it had nothing to do with the clean team.
With respect to that clean team, the rumors floating around that both Lisa Phelps and Sarah David no longer work in this office. Can you comment on that?
That is absolutely untrue. They
Talk
both
to us
work here.
a little bit about the text messages between Ms. Bledsoe and Detective Taylor. She seemed to suggest in one that the information, she says, I did not feel comfortable reading that script before we discussed it, and I swore to it. I'm fine with finding the facts, but between us, I believe we omitted key things from their combined statements. Could you explain what exactly may have not been included in that narrative that she read before the grand jury?
I don't think it's appropriate to discuss what happens in the grand jury. What happens in the grand jury is secretive, and it needs to stay secretive. I think it's normal for detectives and ASAs to have text messages going back and forth about the case. And as to what she meant, you would have to ask her. I wouldn't know what she would mean.
So you stand behind that narrative 100% that she read?
Oh, 100%, yes.
Did you
Absolutely.
I'm sorry, did you plan for a bench trial at some point? Let me reword that.
Please.
Did you have a strategy for whether it was a jury trial and a strategy if it was a bench trial?
Oh, I think there's a difference in how you try the case when there's a jury and when there's a judge. And yes, I think if you look at some of the things that we did in the Porter case, we didn't do in the judge trials, and so yeah, it's a whole different way. I mean, look at the closing arguments in the first of the bench trials. They were as much like an appellate argument as they were like a jury trial argument. So yes, there's a difference, and yes, we planned. We like to think we did a lot of planning, but yes, we did.
So it's fair to say you made the adjustment once the defendant started electing a bench trial.
Well, we made the adjustment. You could ask Judge Williams how effective the adjustment was, but yes, we like to think we made the adjustment.
I'd like to ask you about the independent investigation. When the charges were announced, Ms. Mosby said that an independent investigation had been conducted, and I think the public believed then that you had done a parallel investigation that was separate. As it's played out, it seems as though you reviewed the police evidence as you would in any case and made an independent determination as you might in any case about what the charges are. Was that a misstatement to say it was an independent investigation?
No. You're right. In every case, we make an independent decision. Whether we are relying solely on the police investigation or we're not. In this case, we did our own investigation in addition to the police investigation. And the investigation was conducted by assistants and by we have investigators on our staff who went out and gathered information.
And I can give you specific examples. As early as April 14th, we had our investigators canvassing the area, taking statements, knocking door to door. April 16th, we had, again, our investigators out knocking door to door, identifying witnesses, taking photographs, taking videos. So they continued to go out throughout the entire week. Talking to the community. They took several witness statements. They actually took a video showing the path that Mr. Gray ran. And you have to understand that the community is very reluctant to give names and addresses, but our investigators were out there every day. And then they continued, even when the task force was put in place, to assist the police in getting business videos and identifying CCTV camera videos, footage that we wanted that had not been requested yet by BPD.
Did any of that play a difference in the cases?
When you say difference, I don't. You mean did it assist us in coming to a decision about what to do? Yes.
Mr. Schatzo,
please
Mr. Schatzo, when you were cross-examining Detective Taylor in the Goodson trial, you said that you wanted her removed from the case because you believed she was sabotaging your case. Why did you come to that belief?
Because of actions she had taken that I thought were inconsistent with the role of a detective, and who was the primary detective in the case, and I felt very strongly that that's what she was doing, and so I made the request to the police department.
What were those actions that concerned you?
Well, I don't know about the details to go in. Let me just say that she was doing things without notifying us, and doing things that were counter to what a primary detective should be doing on a case, and she was doing them on her own. And so we brought this to the attention of the police department, and ultimately she was removed, or at least I was certainly told she was removed.
Mr. Schatzo, your frustration with at times was, and Ms. Bledsoe was palpable, I think, especially in the cross-examination of Officer Porter. It seemed like you felt like he was not being truthful, that he was sort of, in a way, did the officer's testimony, do you not believe their testimony is truthful, and that they in fact manipulated the narrative in a way that made this case hard to prosecute?
Well, let me rely on what I said in court, and I stand behind everything I said about that in court. I think that when any person gives testimony, and the testimony is repeatedly inconsistent with what that witness has previously testified to, I think that is a time-honored method of impeachment. There are jury instructions that specifically say you can rely on those inconsistent statements to call into question the truthfulness of the person, and I think that if you go back and you look at the trial record, there were a great number of times when we were able to impeach with prior statements, and that is a time-honored indication that someone is being less than truthful. And when it comes to frustration, I plead guilty.
Beyond the impeached statements, though, do you believe that you had to rely on their narratives to prosecute this case? They were the only witnesses at key points. And do you believe that they were not truthful about their observations?
I think that I'll stand on what we said in the courtroom about that. And I think that in the courtroom, when we had evidence that demonstrated someone, a witness, was untruthful, we argued to either the jury or to the judge that the witness was untruthful, and I stand behind all of that.
Dave, please ask your question.
Would you please finish your answer regarding why police didn't execute the warrants for the cell phones? And I'd like to follow up with how tight did the department circle the wagons on this case?
I think why the police department didn't execute the search and seizure warrants is a question that the police department can answer.
An independent investigator
I
couldn't
think-
have found another way to do that?
I think that in terms of circling the wagons, again, I think that's a question that BPD can answer that I can't answer.
Mike,
When
please
did
ask
you-
your question.
When did you feel that getting a conviction before this judge in a bench trial was really a lost cause in this case?
Lost cause,
I mean, did you think you could get a conviction based on, you know, the past couple verdicts in these bench trials and his rulings?
I think that we, look, hope springs eternal. And I think particularly for the two of us, that anybody who watched us in the courtroom knows that we believed in these cases and we were fighting very hard for these cases. And we would have been pleased to continue to fight very hard for these cases. But at some point, Mrs. Mosby correctly determined that we had to face the reality of that defendants would select judge trials, and that this judge would try the cases, and that this judge made determinations, and that he had seen the significant portions of the evidence that he was going to see. And if this was his view, and I'm not questioning the propriety of his view, I disagree with his views, obviously. We think there should have been guilty verdicts, but he had every right to find the verdicts that he found, and he found them. And we have to accept that as the reality. And at some point, we have to accept the fact that this is a judge. He is finding facts. He's finding them on this particular basis. It is not likely that he is going to start making different decisions, and we have to take that into account in terms of whether it's worthwhile going forward.
I've got a follow-up to Mike's question. Why didn't you ask Judge Williams to recuse himself after the Nero trial? You could have argued he's already been a finder of fact in one of these cases. We felt that we wouldn't get a fair verdict. Now, the judge could have said no, but why didn't you even take that route?
Because there's Maryland case law specifically on point that says that when a judge in a judge trial finds co-defendants guilty or not guilty, there's no basis to recuse the judge. The law on recusal, essentially, this would be recusal 101, is what a judge learns in the courtroom is not a basis for recusing the judge. It's only if the judge is making decisions based on something outside the courtroom. We have no reason to believe that that was the case, and that's why we didn't file what we thought would have been a frivolous motion.
Cheryl, please ask your question.
If I could just follow up about the judge-jury issue. This is a judge who has a history of prosecuting police misconduct for the Civil Rights Division of the Justice Department. And I'm wondering if the fact that this particular judge could not find a way to convict these officers leads you to believe in any way that the case was in fact flawed, that it wasn't a case in which there was sufficient evidence to convict.
No, if we had thought there wasn't, we wouldn't have gone forward with the cases. We thought that there was, and the judge has various backgrounds and experiences. When he sits as a juror, he's taking all of his experience and all of his life experience into account and coming to the conclusion that he did, just as we do with ordinary jurors. And so it has, yes, we re-examine the cases daily. We re-examine the cases and the witnesses daily. But no, we never came to the view that there was insufficient evidence here in these cases.
So can I follow up on one previous question that was asked about the witnesses? There are some witnesses, including Alicia Cruz, I believe, who said just yesterday to one of our reporters that she was never interviewed, and she asserted that
don't, the name doesn't ring a bell with me. And I don't want to talk about her because I don't know what her situation is.
But do you feel that
But-
all the witnesses who were pertinent were interviewed?
Well, you go out to a neighborhood and you conduct a canvass and you let the world know that you're trying to find witnesses, and some witnesses come forward and some do not. And it is, and I'm not saying anything about this person. I don't know, her name does not ring a bell to me. I don't know whether it does to Jan, but we've been around for the last 14 months. We answer the phone. There have been plenty of people who called in and said they have information, and sometimes they do and sometimes they don't. We don't turn people away. So I can't comment on her specific situation, but I can say that we were ready, willing, and eager to speak to witnesses.
What was
Folks,
the game
we have another
changer
3 questions
yesterday?
before we wrap up, okay? So go ahead.
What was the game changer yesterday? I mean, you had heard from Judge Williams his thoughts on the amount of evidence you had in these cases. Why yesterday? And because what a lot of people are saying is that it was a fear of being called to take this witness stand and talk about exactly what information was or wasn't shared among you and the clean team. So I'm curious, what was the game changer yesterday? What the evidence wasn't any different, or I'm just interested in that.
Do I look like I'm afraid to answer your questions?
No, but I'm not.
Okay, so that had, I'm telling you, and I would have told the judge, the clean team was not tainted. I would be happy to answer those questions in a Castigar hearing, because we went to great lengths to make sure that the clean team was not tainted. And they were not tainted. And I would have been happy to testify about that. And so when you say why yesterday was a day we had a proceeding scheduled in court. Yesterday was how many days since the Rice verdict?
8 days.
8 days since the Rice verdict, during 5 of which, thank God, I had a vacation. So, things come together when they come together. We had a reason to be in court, and as the discussions continued and the reevaluation continued, that was a natural day, because we were already going to be in court, to take care of what Mrs. Mosby had decided we should do.
2
And
more questions.
Dr. Carolina never saying Freddie Gray's death was an accident.
excuse me? What?
Is it true that Lisa Phelps disagreed with the Miller case and was asking not to prosecute?
I'm not going to go into the details of what each prosecutor felt on a day-by-day basis. Lisa Phelps was part of this prosecution team from the very beginning. She remains a part of this prosecution team. Everybody has moments when they question a witness, they question a legal theory, they question something else. And for us to start talking about what our work product conversations is just not, that's not conducive. It's not how we run this office.
What about the
Hold on,
legal
hold on,
or
hold on.
legal?
Yeah.
We have a journalist that hasn't had an opportunity to ask.
Can you explain a little bit about what led to some of the discovery breakdowns and what those problems were, and also, I guess, how the knife played into these changes in the theory, and if that kind of contributed to the discovery breakdown?
Okay, so if I were the judge, I'd say that's 8 questions.
Yeah.
But okay, let's talk about the knife for a minute, and then I'll talk about discovery. The knife, and I wish I had the picture with me, but during one day after the charges were brought, the defense wanted to bring their experts to see the van that was parked in the basement of police headquarters. And so we sent somebody, Sarah Akhtar, over there to do it. And she came back with this photograph of an advertisement in the police headquarters. They were advertising with a BPD insignia on it, the very knife that Freddie Gray had on his possession. Now, our theory was that Mr. Gray was arrested before the knife was found. The defendants filed motions to keep out of evidence questions about whether the knife was legal or illegal, and it was our theory that the arrest was made before then, so we didn't oppose those motions, and those motions were granted. So that's the knife story. In terms of discovery, what people lose track of is how much information we did turn over. How many, I don't know what's more than a gigabyte, but whatever it is, I mean, it was a tremendous amount of paper, of disks, of information turned over. And as we would gather more information, we would turn that over. One of the things that's very hard to do, and we haven't figured out a way to do it yet, is to turn over information that we don't have. And so the Taylor documents were given to the defense before they were given to us. They had them. They weren't harmed by the fact that we didn't turn them over. Was that a discovery violation? Yeah, the Court of Appeal says we're responsible for what the police department has. But as a practical matter, how can we do that if we don't have it? The large number of training curricula documents that we got on the eve of trial, those were turned over about 13 hours after we got them. We can't turn them over before we get them.
But didn't you have an opportunity to have
That's
that
the last
discovery?
question.
Well, in fact, let me just follow up with that. On August 4th, we had one of many reviews, case reviews, with BPD. And at that meeting were 3 members from BPD and 2 members of the Baltimore City State's Attorney's Office, including myself. We were given 441 pages of documents that we had not previously been given. And this is the day in the meeting that Detective Taylor says, I didn't take the documents. There were 441 pages that we took. So when we get the documents, we scan them, we review them, and then we turn them over. We had another review in October at police headquarters. There were additional documents then that we didn't have, and we immediately turned those over. But we can't turn over things we don't have.
What about the
Okay, I'm sorry. Cheryl has one final question, and we're going to wrap up. So if you could ask that.
So, if you could address this broad question that is out in the public across America, people feel that justice wasn't done on either side here, that justice wasn't served for Freddie Gray's family or for the police, and that in the end, we still don't really know precisely what happened to Freddie Gray. So, can you just please address that?
Well, you know, we can't know what happened to Freddie Gray unless the people involved tell us what happened to Freddie Gray. Now, they have told us some things, and maybe they've told us everything they know. A trial is not about answering broad questions. The trial is focused on whether the state can prove beyond a reasonable doubt the guilt of the defendant who is charged. And a trial may not be the best vehicle to determine broad questions of public policy, broad questions of what the law should be, broad questions, in this case, of how the police should police, of how citizens should interact with the police. That may not, a criminal trial may not be the best place to do that. But to say that we haven't answered those questions. We have certainly asked those questions. We have provided answers to some of those questions through our expert witnesses, through the testimony that we produced. The defense put on testimony that attempted to answer those questions. And so within the limits of the criminal trial process, that question has been answered as well as that question can be answered in that process. And the fact that people have lingering concerns and lingering questions simply reflects the limitation on the process to answer those questions.
Thank you. Jan, Mike, if you had any closing thoughts you want to share, feel free. If not, that'll...
I don't think that I do.
I don't.
Okay, that concludes the press conference. Thank you all for coming.
Thank you for your time.
Thank you.
Thank you.